Hey Central Louisiana, thanks for tuning in to a new week of What's in Store. This week we're coming to you from Lamb Estate Law. We're visiting with Gwenda Lamb. She's the principal here at this firm. And you guys specialize in the area of estate law, is that correct?
That's right.
Why don't we start by explaining to people exactly what estate law is?
Estate law deals with assets and debts, whether you're disabled or you're preparing for death, or even planning to give away assets right now. So it includes wills, trust, powers of attorney, successions, and probate, to name a few things.
And you've been doing this for quite some time, quite experienced in this area, right?
I've been practicing in this area for 29 years.
That's a long time. So what is the most common reasons why folks come visit you?
Well, I would say that most phone calls are either for successions, to transfer a loved one's assets after death, or to have a last will and testament or a trust made. In the latter instance, when people come in for a last will and testament or a trust, I like to start by talking about disability because that's not occurred to most people. And we address their need for a business power of attorney, a medical power of attorney, and we talk about how powerful the business power of attorney is. You really can do anything that the principal could do with the business power of attorney, except make a will. But we can establish trust, we can transfer property, and we like to make the power of attorney springing. So it's not effective immediately, which concerns a lot of people. So we address that by making it springing. It only becomes effective upon disability.
Okay. Why is it that you think folks don't consider disability in kind of planning for the future?
I think that clients are focused on getting their assets to the people they want to have them, and they forget to take care of themselves.
What steps should a person take in preparing for potential disability?
Okay. Well, it's important to say that most of us will become disabled prior to death. Well over 90%. Now, those periods vary greatly, but they should definitely have powers of attorney, and they need both kinds. You wouldn't go to the bank and take your medical power of attorney, for instance. They need to think about a trustworthy person, not just a child, but possibly a sibling or others.
Well, thanks for tuning in to today's edition of What's in Store.